You're listening to the Patenting for Inventors podcast with registered patent attorney, Dr. Adam Diamond, founder of Diamond Patent Law, the #1 source for securing your intellectual property needs. Now, here's your host, Adam Diamond.
Hello and welcome to the Patenting for Inventors podcast, episode 111. Does your employer own your invention? My name is Adam Diamond, a registered patent attorney and founder and owner of Diamond Patent Law in Los Angeles, California. I can be contacted through my website at diamondpatentlaw.com. That's DIAMENT, patentlaw.com, or call me at 424-281-0162. Now, one of the first things that I ask a client that comes to me with an invention is whether the invention that they came up with is related in any way to the work that they're doing as an employee. Now, the reason I ask this oftentimes is that even though you're the inventor of something, you're actually not the owner of it. This is because that when you become an employee, you probably signed some paperwork that you didn't read, and one of the things in that paperwork is something that says that you hereby assign all inventions made in the scope of employment or something like that. The wording might be a little bit different, and state laws may vary the wording in there, but these are called Proprietary Information and Inventions Assignments Agreements, or PIIAA. It also might be called Confidential Information Inventions and Assignment Agreements, CIIAA. And these obligate you to assign, which is just a fancy word of saying sell, your invention to your employer. Now, you might think this isn't fair, that you came up with the invention, you should own it. But from the employer's point of view, your employer is giving you a salary, whether or not your invention works or not. And in return, if you do come up with something that's worth patenting, your employer wants to reap that reward. So if you invent something and you're an employee, does your employer own your invention? And the answer to every legal question is maybe. Let's look at the extreme cases where the answer is probably pretty simple. Let's say you aren't an employee, you invent something, and you happen to get a job somewhere, and you sign something saying that all your inventions are owned by the company. If you didn't invent it while you're an employee, then it's your invention. You use no company time and no company resources to invent it. Now, on the other end of the spectrum, let's say that you work at a knife factory and you invent a new knife handle, and you're using work computers, you're using work time to create this new knife handle, and you sign something saying that all the inventions made in the scope of your employment belong to the company. Now, that's a pretty clear-cut case that the employer owns the invention. Let me also clear something up. Your name as the inventor will be on the patent, or at least by law it has to be, because inventors' names are always listed on the patent. But the owner or the assignee will also be on the patent, and that will be the company name usually. Now, everything is not so black and white, though. There are lots of situations that might be in a gray zone that will tilt one way or the other in terms of ownership. Now, how it ends up may depend on your state law, the labor code, what you sign in the contract. I'm going to talk about California because that's where I am, and just as a side note, I can take clients from any state, because patent law is federal law, so we can work from clients from anywhere, even internationally, when we file things with the patent office. But here in California, there's a California Labor Code, section 2870, and it says that essentially assigning the invention does not apply to an invention that the employee developed entirely on his or her own time without using the employer's equipment, supplies, facility, or trade secret information. Now, that sounds pretty cut and dry, but what if we're at that knife factory and you're very careful not to think about your new knife handle while at work? You only think about it at home, and you only use your home computer to work on the design. Maybe you think you're in the clear, but not so fast, because there are some exceptions, of course. The labor code says that there's an exception if your invention relates at the time of conception or reduction to practice of the invention to the employer's business or actual or demonstrably anticipated research or development of the employer. It's a little bit legalese, but what this means is that if you came up with a new knife handle, this knife handle probably relates at the time that you conceived it to the employer's business. And it probably could have been anticipated that this knife company was going to be developing knife handles. This would probably come down to the word what relates mean or related means. Are knife handles related to knives? There's a good argument that it does, even if they aren't creating that product line right now. Now, nothing's cut and dry. You can always try to argue that the knife company you work for had no interest in anything with knife handles. All they were interested in was sharper blades. Now, maybe you'd win that argument, maybe you wouldn't, but it's just something to think about on who has the rights to the invention. So maybe you're thinking that it's really hard to come up with an invention that has absolutely nothing to do with the job that you're in, and you might be right. And it might be really hard to get around your employer owning your patent. Now, if you work at the knife factory and then you go create a new yo-yo, and then you probably have a good chance that your employer isn't going to own it. But I still highly recommend not doing anything with creating your new yo-yo while on work time or using work equipment, or else your company might make the argument that they own it. Now, also remember that if you're in California, and other states may have this as well, that you probably signed a non-compete agreement, which means that you're not allowed to leave the company and then go into business that competes with the company. Now, luckily, if you're in California and probably a lot of other states, non-compete agreements are generally unenforceable because there's a policy that wants to make it easy for people to switch jobs if they want to. But this kind of causes a conflict because maybe you want to break off and form another company, but the way that you're forming this other company is that you're using ideas that you conceived of during your employment. Now, California likes to give leeway to the inventors and employees so that they're not always beholden to their old companies, but nothing's going to be a slam dunk. If you created your idea based on trade secrets from this company, there's a good chance that the company is going to say that they own your invention. Now, if you do go to a new company or you form your own company, you really want to start your ideas from scratch and not use anything from your old company, just so you don't have your old company coming after you, requiring that you assign all your inventions to them, even though you're not even an employee there anymore. So the takeaway is, if you're an employee, you still likely own your invention if it has nothing to do with your employer's business, and it really helps if you didn't work on this invention at all during work time or use work equipment. If the invention relates somewhat to the business, but you didn't do anything on company time or company equipment, it's possible that the company still owns your invention, and we just have to look at the facts in the case. So to sum up the factors, there are going to be three main factors. It's going to be when, what, and knowledge. When did you conceive of the invention? Was it work time or not work time? Work time favors the company owning it. Non-work time favors you owning it. The second one is what? Does the invention relate in any way to the things that the company does? If yes, it favors the company owning it. And if no, it favors you owning it. And lastly is knowledge. Did you use any knowledge to create your invention from your position as an employee? If the answer is yes, it favors the company owning it. If no, it favors you owning it. And as I've said plenty of times, there's usually no black and white answer, and that's why attorneys exist. So when coming up with your invention, try to make sure all the factors weigh in favor of you owning your invention and not the company. If you want help with your patent application, trademarks, copyrights, responding to rejections, appeals, or anything else related to your invention, you can contact me directly through my website at diamantpatentlaw.com. That's DIAMENT patentlaw.com. Email me at adam@diamantpatentlaw.com or call me at 424-281-0162. I'm Adam Diamant, and until next time, keep on inventing.
Thanks for listening to the Patenting for Inventors podcast with host Adam Diamant. If you enjoyed the show, please rate and review on iTunes. The contents of this podcast are intended for general informational purposes only. The facts of every legal matter are unique, and the content of this podcast should not be construed as offering legal advice for your specific legal situation. For more information and help with your own intellectual property needs, contact Adam Diamant at patentingforinventors.com. That's patentingforinventors.com. Or call Diamant Patent Law at 424-281-0162. The preceding information may be considered an attorney advertisement and does not establish any attorney-client relationship.